Please, Your Lordship, I beg to mention item number 6.
Number?
Item number 6. I pray this matter may be listed after 2 weeks, Your Lordship.
Oh, this is for filing of that of a written argument.
My lord, the parties has exchanged that filing. That is fixed for refreshing lordship.
Oh,
For that purpose
because
only, limited purpose only. So my friend is taking time. 2 weeks, hopefully, the next occasion may not be finished.
5 and 6 connected, otherwise our Lanet AG is available today.
on premium by the petitioner. This is matter of the 2 weeks. So 5 and 6 will be
Connected, yes.
since they are connected. 5 and 6.
Please, Lordship, I beg to mention item number 8 for the private respondents.
I have no objections, Your Lordship.
You are appearing for all the respondents?
Yes, private respondent, yes, Lordship.
All the private respondents.
And for the state matter, 1 to 5.
On premium by the private respondents, not objected to by petitioner. This is matter of the 3 weeks.
Deeply obliged, Your Lordship. Your Lordship, I beg to mention item number 4. Your Lordship, I pray that this matter come up after 2 weeks, Your Lordship.
On premium by the petitioner, this is matter of the 2 weeks.
Your Lordship, I also beg to mention item 9 and 10. Your Lordship, this matter is still pending before the Supreme Court. So I pray that this matter,
Your Lordship, that.
But
I pray that this matter come after 3 weeks.
Transport Inspector,
Lordship, yes. Correct, Your Lordship.
on premium by the petitioners, this is matter of the 4 weeks.
Apply.
Supplementary cost list, item number 1.
See, I'm very sorry. I have to. I was preparing the judgment.
Yes, my
I'd gone through your whatever is there on record.
lord.
You had annexed a copy of the plane,
Yes, my lord.
but the annexes are not there.
Uh,
In the plane, reference was made to some pata,
yes, my lord.
and
Yes, my lord. Yes, my
that would be relevant as far as
lord. I see. I see.
ascertaining the facts. Are
I can give it right now, so I have a copy.
Should I call for the case? Court reports.
Because the entire plaint, my lord, I had, for the purposes of hearing, I was anticipating that lordship may want to look at the documents during the hearing. I had prepared a copy, my lord. If lordship allows, I'll hand it over right now, my lord.
Yes. Would that be the? Yes, Mr. Patel.
Yes,
Yeah.
lordship. It's matter of record.
It's his plaint, my lord.
You should have done it. At the first instance.
I should have maybe.
I
That
had
was.
just taken it for granted that it's there.
Maybe that was a lapse on my part. I deeply apologize for that, my lord.
This matter was called up. All parties are present. This matter was called up on the query of the court as to certain documents which are relevant for consideration but have not been annexed to the petition hearing. Such document being the complete set of the copy of the plain file in the title suit number 15D of 28 before the trial court. Mr. S. General Learned Counsel for the petitioner has submitted that the copy of complete set is in his possession and has accordingly produced the same today. On the same not be objected to by the learned counsel for the respondent. Such copy is hereby taken on record and marked as annexure X. Accordingly, the matter is now reserved for judgment.
Item number 2.
What is this?
As lordship, this is the miscellaneous petition file, your lordship. This in writ petition number 198 of 2019, your lordship, it is finally dismissed on 17 February 2023, your lordship. So after that, your lordship, there was some delay to file implement this order, and this writ petitioners opposite party hearing, they filed the contempt petition against this order. So your lordship, when on the process of it, then ministry find that it will not be possible to implement the judgment, and as because this we cannot go for even appeal to the division bench the matter, because earlier matter was disposed of by the Supreme Court. So ministry has given the instruction to file the SLP. So it is on the process. So your lordship, we need some time so that
This is related to the contempt matter.
with contempt matter.
Lordship, in
So,
the contempt matter,
because the matter is like that, your lordship, the Supreme Court has given the direction. On the basis of direction, order was implemented. So on the basis of it, this court has passed the order to consider the petitioner's hearing in the writ petition. So when it is going to be implemented, then fine. Then this will be another problem, because whole recruitment for the even other branches, so it will be affected, and there will be similar places, and then other treatment come up. So until and unless Supreme Court it is considered whether it is feasible or not, other court cannot, because already Supreme Court passed the order. Even if we go to the division bench, and it will be fruitful. So this minister has given the instruction
See,
to file the SLP.
Mr. Devnath, instead of filing an application for extension of time, we're now, excuse me, you have clearly stated at the bar that the parties, rather the Union of India, is contemplating filing a related application before the Supreme Court
Yes, sir.
against the judgment.
Yes, sir.
So that is your instruction.
It is.
Why would you file this application for extension of time?
Lordship, on contract,
What you could do is in the contempt itself, file a reply, and then the matter would be heard.
Lordship, in the contempt petition, they have already filed a reply, the affidavit in opposition, whereby they have stated that the MHA is taking the matter into consideration. Now they're coming up with this plea now, saying that they wanted to file an SLP. Now they're taking contradictory stance, Your Lordship. Now what about the affidavit filed in the contempt application, Your Lordship? They're taking contradictory stance, Your Lordship.
Because
now,
in the affidavit, Your Lordship, when it was
so
under process, Your Lordship, it was under process by the ministry. So we have given this affidavit on the basis of it. So now subsequent development is there that it is required to file the SLP. So that's why we brought this notice by this insurance application.
Lordship, as on date, there is no SLP filed by the union. Because
this
Lordship, a bare perusal of the application will also see that there is no case diary mentioned there. What is the case diary filing number of the before the Supreme Court, Your Lordship?
We are coming in the clean hand before this honorable court because
that is a different thing, sir. You could have made a submission in the when the contempt matter comes up.
Lordship,
not in this manner.
Lordship, my prayer will be because the contempt is listed on 21st. This application also be listed along together with the contempt application.
You see, I find no reason why this application should be filed.
Lordship, now after contempt application has been filed by us.
If you have to take necessary steps, you do it, and inform the court, and the matter will be, will be judged on the basis of the law prevailing. And what is the principle involved?
Because, Your Lordship, this minister has given the instruction to file, so department has approved.
And we'll take it up as Mr.
On 21st, Lord.
As paid for by Mr. Artamna, learned CGC. List this matter on to 21st.
Obliged.
Daily cost list, item number 1.
The report has been called for from the doctors of Silchars.
Yes, any.
This is Your Lordship. Lordship was pleased in the last occasion. Your Lordship was pleased to direct the Assam Valley Hospital.
That particular doctor.
A particular doctor to furnish a report. Your Lordship is not aware whether the report has been filed or not.
Whether I don't, because the report was called directly from the concerned hospitals.
The order was passed on?
The order was passed on 5th of this month, Your Lordship.
5th February.
That order has not been uploaded, Your Lordship, in the website. Most probably it has not been uploaded. That's why, Your Lordship, I could not.
Yes, 28.
Only the order of 28 has been uploaded, Your Lordship, in the website of the. Only these two order 28, 12, 23, but 5-2, Your Lordship. Uploaded, Your Lordship, because the order dated 28, Your Lordship, say that let this matter list on 5-2-2024, Your Lordship. But this order of 5-2, Your Lordship, has not been.
But 5-2 order is with regard to the bail applications. But the court passed an order in the miscellaneous applications filed for the extension of the bail granted, interim bail granted.
Where's the order of 5-2?
It was passed in the criminal means application number 3 and 4. It will be the, and so far the bail is concerned, it is different. It is 68 and 69. 68, 69 is bail application pending, wherein the Honorable Court has granted the interim order, interim bail, and subsequently, before the expiry of the bail, interim bail, I filed an application for extensions. And this, in the criminal misapplication, court passed some direction to the Assam Valley Hospital to produce the medical of the accused person, petitioner's hearing.
The office note says the report has not yet been filed on behalf of the medical superintendent, Valley Hospital, Assam.
Then Lordship will direct him to
File it on the next date, otherwise
personal appearance of that particular person, Your Lordship. He has to comply, Your Lordship. It's a judicial order, Your Lordship. He has to comply.
When is the interim bail expiring?
Interim bail is till today.
Till today.
Today, yes.
And what is the situation now? What is your instruction?
My instruction is that she is under the treatments, still under treatments.
Treatment at that hospital or?
In that hospital under the review. Only 2 days back also she went to the hospital. The doctor said that the review will be take 2 months. After 2 months, after the review is completed, then the operation will be conducted, as per the last report.
I think the interim bail had already expired, Your Lordship.
No, not expired. It is extended, Lordship. In the miscellaneous applications, in the miscellaneous application, the court may see the interim bail is already extended.
Expiring on 1/2/24, Your Lordship.
That is correct, but it's extended again. It will continue till today.
Yes, till such time the report is filed. This is the order in the
miscellaneous applications.
The Lordship will kindly cause the personal appearance of the particular doctor.
We'll give him another chance.
Lordship, yes. Ask Lordship, please.
At least 10 days time.
Lordship. Only, Your Lordship, I have a prayer, Lordship, that the accused also on the next date should file the status of the.
We will file it in case
You'll be in a better
Because
position to get.
as of now, we are not aware, Your Lordship. Where is she?
Yeah, because you are in contact with the doctor.
Yes, I'm in contact.
He will, as Mr. Shulai said,
we will file it.
He will give you all the reports as necessary, and you can file those.
Okay, we'll file it.
Heard there are counsel for the parties. This court, by order dated 29/1/2024, Kaliya criminal miss case 3, had directed the medical superintendent of Valley Hospital and Research Center under bracket P Limited to file a report, a medical status report as far as the treatment of the petitioner, as far as the treatment of the accused person, Srimati Kim Nekol Nokongsa, is concerned. However, the office note would show that such report has not yet been filed till date. It is next. It is the submission of the Leonard AAG that this court may await the filing of the said report, failing which the personal attendance of the said medical superintendent be directed. It is also submitted that the accused person who is undergoing the said treatment be also directed to file the relevant medical report on the next date fix. Mr. M.F. Kursi, Learned Counsel for the petitioner, has submitted that the accused person is still undergoing treatment. However, the exact situation could not be confirmed. This being the case, it is submitted that the report as directed be awaited by this court. On consideration of the submission made, this court is in agreement with the Leonard AAG that some more time be given to the said medical superintendent of Bali Hospital and Research Center to file this said medical report as far as the said accused person, Srimati, is concerned. Accordingly, let copy of this order be issued upon the said medical superintendent for compliance, failing which necessary orders shall follow. Necessary orders and directions shall follow. It is also incumbent upon the accused person to file the medical report on the next date fix.
It will come on 21st. If Lordship has given 10 days time, then let it come on 22nd, Your Lordship.
As
today is 13, Your Lordship, then
as
22nd.
Before this matter on Shuai Katua. In the meantime, the interim bail granted is hereby extended till the next date fix. This is matter on 22nd.
Lord, highly apply, Your Lordship. 1, 2, Your Lordship. Same order.
Same order.
Lord.
Item number 3.
This is matter only.
What about the earlier list we will have? I made business, Your Lordship. Lordship, I have the instruction, Your Lordship, that the managing committee had been constituted and approved by the governmental authorities, Your Lordship, on 15 Jan 2024, Your Lordship.
So have you filed the affidavit?
No, Your Lordship. I have not.
You're supposed to file it by way of an additional.
I'm sorry, Your Lordship, because but the fact remains it has been approved, Your Lordship.
Yes, true.
We'll
true.
bring it
But
on
has to be,
by an
be
affidavit, Your Lordship, and they'll have to
In the meantime,
take step, Your Lordship, because if Lordship kindly come to page 27. Page 27, Annexure 7, Your Lordship, appears, Your Lordship, that the
page 27 of the
writ petition, Your Lordship. The managing committee, Your Lordship, the earlier managing committee, Your Lordship, appears, Your Lordship, and the present one are not the same people, Your Lordship.
Not the same people.
Not the same people, Lordship. They are in a better position to
I will seek instruction.
to highlight, Your Lordship, to inform your Lordship.
Perhaps the government will file an additional affidavit, then the matter will be cleared.
Yes, once it is on record,
we'll file it,
you
Your
take
Lordship.
steps.
A week's
Then
time
we'll
only,
take
Your
the
Lordship.
steps, Your Lordship. Let the affidavit be on board, Your Lordship.
Mr. Joshi,
Your Lordship.
you are appearing for the managing committee.
Yeah, I am appearing for the managing committee, Your Lordship.
The new managing committee.
Managing committee, Your Lordship, I am.
Managing committee means old or new?
I was for old, Your Lordship, new one, so I don't have any idea about that. I will seek instruction, Your Lordship, and I will come on the next day.
Off the record,
Right,
you just
Your
seek instruction and see.
Your Lordship.
How?
So we'll, Lordship, just to bring on record, Lordship, we need only a week's time, Your Lordship. A week's time.
Mr. Andy Shulai and that EAG has submitted that it is that a new managing committee of the said school of this school. Okay, go to school.
Kendong.
Domsco.
What is the full
Lordship,
form?
this is Domskong LP School.
Domskong
LP School. Mawson Ram, Your Lordship. Mawson Ram,
Mawson Ram.
CRD block.
East Castles has been. Kung ito nga, umiyan na stang has since been constituted and approved by the concerned authorities. However, the same will not be brought on record by way of an additional affidavit as directed by this court in its previous order dated
After a week only, Your Lordship.
5/2/2024. It is prayed that a week's time be given for the said
Lordship.
additional affidavit to be filed. Pray aloud. This is matter thereafter.
Obla, Your Lordship.
This is matter to a week.
Item number 7.
I have also submitted my written submissions, my lord, in this matter.
My lord, so far my part is concerned, I had submitted my written argument as well as the oral argument was also done exhaustively, and then the respondent had said that they would file.
This is with regard to that interest.
Points of, yes,
Interest. My lord. The only issue, my lord, which I canvass, my lord, is whether the respondents have delayed in payment of gratuity to the petitioners. Now there were two directions. It is not a case before this court that whether act of gratuity is applicable to us or not. That has been settled, so we are not on that. But then,
so now,
yes,
if not in this matter, but in some other matters,
yes,
it has
yes.
been confirmed that the
Correct.
gratuity, payment of gratuity act is
yes,
applicable.
yes, and yes,
So that
and
part
that part is finished. And originally, when that order was passed by then the retired Justice TNK Singh, and he directed us to pay the amount of gratuity within a period of 4 months. This was challenged before the division bench, and the division bench upheld Justice TNK Singh's order. We went to the Supreme Court, and in the Supreme Court allowed us to go back to the High Court by way of a review petition. We came back to the High Court by way of a review petition, and after that again the review petition was dismissed against us So against that order, we went to the Honorable Supreme Court by filing an SLP. And in the SLP, while we filed the SLP, notice was issued to the petitioners as a respondent in the Supreme Court. Notice was issued, and on the day when it was heard, then we gave an undertaking, okay, we will not argue on this matter, we will pay to the people who have taken VRS. And Supreme Court gave us, you pay within 1 month. Justice TNK Singh said, you paid within, Justice TNK Singh in the year 2012 said you paid within 4 months. But then Supreme Court has said you pay within 1 month. So this order has already culminated March by the order of the Supreme Court.
So, see, finally, it will be the Supreme Court's order which will stand.
Which will stand. So within 1 month, we have paid to them. We have released the amount of gratuity, which they are also not disputing. So therefore, when the direction have come, and all these lists were before the honorable courts, we were not deliberately sitting over, but we were seriously agitating the matter. Finally, we gave as a good gesture, we have given to them. Now they come back and they're saying that no, you have to pay us the interest. So that is the only case.
Mr. Khan, I don't think you have a case.
Malad.
See, the fact is, you see, finally it is the Supreme Court order which will stand.
Yes.
When the matter, you see, has travelled, you see, it has travelled from the, single bench to division bench, back and forth, all those things. So that period, more often than not, would not count. Would not count as far as, calculation of the period of delay or whatever is concerned.
Yes.
Because the matter is still under litigation. Nobody knows what would be the decision of the Supreme Court.
Yes.
For all we know, it might go against you. But of course, it has gone in your favor. I don't think you should.
Malad.
I don't think you should.
No, Malad. Yes. My contention is this: that although I have given my exhaustive hearing in along with the judgments also, that even if interest is not claimed for, we are entitled to the interest for the delayed payment. Now, fact remains here is this, that the delay that has been occasioned in this case is that who has dragged us? It is they who has dragged, because had the amount of money paid at the time when we were supposed to pay by the controlling authority, then matter would have ended. I had argued matter. Now, fact remains that it is they who has dragged us till the apex court. Now,
Mr. Khan,
there are
that would not be, that would not be a sufficient, contention or argument on your side. It is not a question of who drags who.
No,
it's a question of exercising one's right. Everyone has a right to appear before or go before any appropriate authority, forum, High Court, Supreme Court.
Yes, yes.
So you cannot say that you were dragged.
No,
you have been made party, so you have to.
Yes.
My lord, the thing is that I have there are ample number of judgments also which have stated also that we are entitled to the interest. We are entitled to the interest on the delayed payment. I have made my submission on the last occasion also that in fact there is nothing on on the part of the respondent to establish that the delay in the payment to the petitioner was occasioned by the petition's fault. The burden is on them to show that they are not guilty, culpable of delay.
What is your calculation of the delay? From which period? From before the institution of the
from the date when I am entitled for payment of gratuity. From the date, because it is.
But as far as your entitlement is concerned, you see, that has been, challenged.
That's true. But the fact remains that who has brought us into litigation? In fact, had the controlling authority at the first inception paid the amount, matter would have been. It is they who had dragged us to the litigation right to and the matter got stuck. And ultimately, when the Supreme Court, apex court passed the order, then they had to pay. So all this, the culpability in the delay in the payment, I'm entitled to that interest. You know, my lord, if we take the analogy of the motor accident case, is also same thing. The amount matter keeps on pending, and at the same time an appeal is also filed. And when the appeal is disposed of, we are entitled to the discretionary power where the court passes the order for payment of interest. That can be said that we are not entitled to interest.
We will have to see whether the relevant acts, would be on the same footing or not. The principle would
Yes,
apply.
yes.
So that
Yes, and it's,
payment of gratuity act.
Yes,
and
it provides.
the
It provides for interest.
Motor vehicle act are two different acts.
Two different acts.
I'm just drawing the analogy.
If there's any provision which is paramaterial.
Yes, So section 7 of the payment of gratuity speaks about the simple interest. It speaks about the simple interest. We are entitled to payment of the gratuity at the time within 1 month of the date.
I think section 173 of the Motor Vehicle Act.
Very true. That's so far I am concerned, I'm just drawing the analogy that how payment of interest is. Now, had it been a case that we were culpable of delay, then we would have just kept shut. But it is they who had dragged us up to the Supreme Court, and then the money was just kept lying like that. Ultimately, when the order was passed by the apex court, then they made payment in the year 2019. It is they who had dragged. So during all these years, the amount of money which they ought to have been paid at the first inception, they had by the controlling authority when the matter won the first instance. Then from there the litigation they had started. It is they who had dragged us into litigation, claiming that we are not entitled to gratuity. Had they succeeded, matter would have ended. But they failed. So during those periods,
now we are not on that.
The
only thing now is whether you're entitled for the
interest on
interest with effect from 2012.
Yes, my lord, from the date of the passing of the order of the single bench, I am entitled.
Where 4 months time was given.
4 months, yes, my lord. And my lord, very quick rejoinder also, my lord. Now this was a case which was going on since 2008, my lord. At any forum, my lord, either before the controlling authority, before the learned single judge, before the division bench, before the Honorable Supreme Court, they have never talked about the interest. And on the last day, my lord, when we gave an undertaking that we will pay, now giving a concession in the Supreme Court that we don't want to fight and we will pay them, that does not mean, my lord, that we have hang our boots and then the law has been laid. It does not mean, because as we say that as a good gesture we have given to them, my lord. And my lord, yes.
Mr. Ewan, what you have done is when a concession was made before the
Supreme Court, yes,
it was not made in the air.
Yes.
It was not a gesture of
it was not
of goodwill that
matter of right.
no, you are not entitled, but anyway we will give you.
Yes.
But it is based on some legal provisions, some act that is in place, which is the Payment of Gratuity Act. It is based on that, and on that basis, what happened is the provision of such act would apply,
my lord,
to the proceedings.
Yes. What my lord is saying is also true, but what legal advice that we have given is because we have to see the background as to how this golden handshake scheme has
you
come
have not
to
qualified your submission.
Yes, and also, my lord, what I was just trying to say is, till Supreme Court, when Supreme Court says that you pay them within, if you are saying you wanted to pay, okay, you pay within 1 month. They were represented. They never talk about interest. They've never talked about interest. All this while, they have been keeping quiet. For 18 years, they have been keeping quiet. So now, the constructive res judicata also will be operation against him.
We'll have to look at the aspect of a forfeiture.
Yes, my lord. Yes.
Whether by their silence means they have forfeited that claim.
Yes.
Or otherwise.
Yes. Because the rule of pleading is very sure. If you want to claim, because now, as they said, from the controlling authority, means according to them, it's already been delayed. They had an opportunity to raise the interest. they've never raised the interest, my lord, because they themselves were not sure which line it
No,
will
my
go.
lord, there are, in my written argument I've also submitted, there is a judgment also of the state of Bihar. In Champaran's case, it is mentioned that even if the interest is not claimed for payment of the gratuity, we are still entitled to, because the law provides, by virtue of section 7.3, when the law provides for payment of interest, we cannot go against the law. If the law is silent about that, that depends on the discretion of the court. But when the law provides for payment of interest and the delay has been occasioned, that there is no fault on our part. So my friend has made a submission before the court saying that this was a concession. As a matter of fact, it was never a concession. It was a matter of right. It was a matter of right, and they had challenged that, and ultimately they failed to succeed. And the apex court has also decided that no, it is a matter of right, payment of gratuity. So ultimately, all these years when the matter was dragged up to the apex court, the delay has been occasioned by them. And who is the sufferer? What prevented them not to pay at the first instance when they have taken a U-turn? And then the litigation from single judge and the intra-court appeal and then the apex court. So all these years throughout, the matter, the amount of money which ought to have been paid at the first instance on the basis of the Golden Hands scheme was not paid to us. They had made all the efforts that we are not entitled to payment of gratuity. But ultimately, when they fail, when the apex court had given a decision that yet we have to pay within a period of 1 month, if my lord has passed the orders that the amount of money has to be deposited within 2 months. But at the same time, what about the interest? Payment of money to deposit within a certain period of time is one thing. Entitlement of interest for delay occasions where we are not culpable of that part and where the law provides for the interest, and it is supported by judgment, in ample of judgment, that even if the interest is not claimed, the court can pass interest because the law, section 7, clause 3 of the Payment of Gratuity Act, clearly envisages that we are entitled to payment of gratuity. The only thing is that it has also provided in a proviso, if due to the fault of the employee,
No, of course. So you are contending that it was not your fault.
Yes, and there is an ample of judgments which I have supported in my written argument. My lord can objectively examine those judgments and arrive to a conclusion that whether we are entitled, I have made my exhaustive argument that we are entitled to the interest on the delayed payment because the law provides, and the ample of judgments which have justified that yes, I am entitled by virtue of section 7 and subsection 3 of the Payment of Gratuity Act, which clearly envisages about the interest. Because interest will accrue, it has to be paid within 1 month from the date of due, when it is due. But once it is not paid, and due if it is due to the fault of the employer, then fault employer in the case that they had dragged the matter up to the apex court, and ultimately when the apex court had decided to pay within 1 month, that does not mean that payment of within 1 month that they have discharged the liability. But what about the time period that they have taken during all those days?
The factual aspect and the legal aspect will be considered.
Yes, my lord. It's a very, very dangerous propositions my learned senior are making, my lord. Which means that if anybody, the constitution allows, the provision of law allows for an appeal and a revision, whatever it is there. Suppose if somebody goes, then it will be health responsibility on one way or the other way. This is what he is trying to put. It's a very dangerous propositions, I must submit, my lord. That is all.
This court will produce the written submission.
My lord.
Mr. P. Ubin, counsel for the respondent number 2, has submitted that the written argument on behalf of the said respondent is filed today. State is not filed.
Lordship, my only submission is that your Lordship will kindly consider the order 2, rule 2, sub rule 3 of the CPC, Lordship, because in the initial stage they have omitted to claim that a relief interest, Lordship. Whether at this stage without the leave of the Honorable Court, whether they make that clear.
Of course, that Bihar judgment is there.
Bihar judgment.
You have to look at it.
Yes.
Mr. Indisha, learned AG, on the other hand, has submitted that no written argument will be filed on behalf of the state. However, in continuation of the argument tendered, the learned AG has laid stress on the provision of Order 2, Rule 2,
of the CPC, Your Lordship.
Sub-Rule 3.
Order 2, Rule 2,
Under
Rule 3 of the CPC.
CBC, to say that there was no pleading, no initial pleading on behalf of the petitioner,
They have omitted that claim, Your Lordship.
and the claim has been omitted at the time of,
In the previous litigation, Your Lordship.
since initiation of litigation at all times, as far as this matter is concerned. On consideration of submission made, this matter is now reserved for judgment.
Item number 11.
Good afternoon, Your Lordship. For the respondent.
Yes, sir.
We have come against grant of bail, my lord, under NDPS Act. It was a case of commercial quantity, my lord, and the learned trial court has granted bail. In fact, there are several cases, a batch of cases, my lord. Today itself, today 4 matters are listed, my lord, 12, 13, 14, 15.
They are all arising out of the same case.
These 4 are out of same, my lord.
You are appealing for all, Mr. Yadav?
No, I'm just for this particular one, Your Lordship.
Who's appealing for the others?
I will be for,
Sorry.
I will be for 13, 14 and 15.
You have come with application for cancellation of the bill or violation of the bail conditions.
No, my lord. We have come under 439(2) read with 482, my lord, because there is no
That's for
provision for
cancellation.
appeal, my lord, as such. So, we have not come for violation of any condition, my lord. We have come against the exercise of jurisdiction by the trial court in granting bail in NDPS cases, my lord.
Four 39, 2.
49.
Yes. This is for cancellation of the bail.
So they have come for cancellation of bail, you know, sir.
But who has granted the bail?
Special judge, my lord. Land special
Why
judge.
have you not approached the special judge? Provision is very clear.
In fact, there is some Supreme Court decision I took out, my lord. Why we come under 439(2), read with 482, my lord.
As far as the issue of cancellation of bail is concerned, first, see, it would be incumbent upon you to approach the same court which has passed the order. It could be the Court of Sessions or it could be the High Court for this matter.
Right.
Thereafter, the matter will be decided and heard. But if you have come against an order of grant of bail by a Court of Session or special court, whatever the case may be, before the High Court, then it has to be, by way of an appeal or revision.
397. Correct.
So,
but because in CRPC there is no provision for appeal against bail order, my lord.
But a revision is there, your lordship.
Because there are, for some reason, my lord, those judgments have been left out. The matter is taken up tomorrow also, I can have.
Tomorrow I will not be free, sir. Tomorrow I will
Day after tomorrow.
1 week.
Normal course.
On pre made by Leonard DSGI. This is matter of 1 week. Are you satisfied this court?
Yes, I have decisions directly on that, my lord.
It would, I may be wrong, but
because
if the court exercises this power, it would be a revisional or appellate power, not under 437(2), 439(2). Had it been an order of bail passed by the High Court, then.
But I can satisfy, my lord. There are Supreme Court decision directly on this point, my lord, which says that there is no provision of appeal under CRPC against an order granting bail, my lord. Because the 436, 437, 438, 439 are concurrent provisions, my lord. So only remedy, because we are not come against violation of any bail conditions, my lord. If it was a case of violation of any bail condition, then it was incumbent upon us to approach the same court, my lord, that they violated the bail conditions and to cancel the bail. We are not for cancellation of bail, my lord. We are for examination of the propriety of granting bail, my lord.
And that would amount to the same thing. The end result would be whether the order is either erroneous or not.
My lord. And 439 read with 482 is the remedy for that, my lord. I'll place the decision, my lord.
Next week.
Second call, item number 11.
Deeply
obliged.